Chairman, Excellencies, delegates, ladies and gentlemen, it is a pleasure and a privilege to share my reflections on child rights mainstreaming in the UN, and I thank the organizers for this valuable opportunity. My statement today is informed by a range of perspectives. First and foremost, on my lived experiences as a mother and a grandmother, as a human rights academic and an activist, as a teacher, and in particular, a researcher in child rights. And finally, in the past couple of decades, I have had the opportunity of being a member of Special Procedures, the Working Group on Arbitrary Detention, and Investigative Mechanisms, the International Independent Fact-Finding Mission on Iran. So why should child rights be mainstreamed? Why should they form an integral and pivotal aspect of any initiative on human rights, including investigative mechanisms? How will the absence or presence of child rights mainstreaming impact on the outcome of any mechanism? These are some of the questions that I will try and highlight in my statement. I would like to place the importance of child rights mainstreaming, especially in the context of investigative mechanisms within the UN. The cliché that children should be seen and not heard is informed by the notion that children lack the competence and experiences to say and do what is in their best interest, how they feel, and what drives their feelings, their doing and being. Changing the above mindset is what will entrench child rights mainstreaming in a natural and seamless manner, rather than a mere add-on to how we perceive and address human rights and any violations thereof. I've had the privilege of serving as a member and then vice chair of the Working Group on Arbitrary Detention, and in these intense 6 years of my professional experience, the working group received hundreds of complaints of arbitrary detention from around the world. Although other than a small percentage of complaints filed by or on behalf of children, the vast majority of detainees were adult men. However, we felt as a group that in order to protect human rights in a holistic manner, women and children have to be placed at the center of this discussion. Detaining a male who's a father and a breadwinner of a family meant placing children and women in that family in a vulnerable position. Although done consciously by the group, and that is what we adopted as a group, child rights mainstreaming requires continuous vigilance and explicit guidance when writing opinions. It is only when a solid body of jurisprudence is developed that child rights mainstreaming becomes part of how these mechanisms operate and implement human rights effectively. A recent example of good practice in child rights mainstreaming is the resolution establishing the mandate of the International Fact-Finding Mission on Iran, which was unequivocal in its focus on human rights violation of women and children. This explicit focus helped to ensure that violations affecting children are adequately accounted for. And thus, following our mandate, throughout the investigation, we kept a vigilant eye to maintain the focus on children, starting from planning, information gathering, analysis, reporting, laying out investigation priorities, designing investigation plans and tools, as well as the various stages of analysis and reporting. We were thus able to position child rights issues and children's engagement and visibility as an overarching pillar. Children who spoke to the mission spoke as witnesses and victims of human rights violations, and the manner in which they articulated what they endured and how their individual ordeals left a lifelong scar which they would carry for the rest of their lives. They recounted their perspectives, their fears and aspirations for justice and accountability of those individuals and institutions whom they considered responsible for their suffering. So what was the approach that we adopted? Integral to our approach was the no harm principle. So as we engaged with children, we also weighed up any potential risks of harms associated with gathering information, and we thoroughly assessed them. And in some cases, in the safety and protection for children, we decided not to engage. As we maintained the right's focus on violations affecting children, it was imperative to discern through the investigation violations and incidents where children became the direct target as well as becoming an indirect and ancillary targets that are equally important for us to bear in mind. The key lessons and takeaways were that unless we are able to ensure a greater engagement with children effectively and thoroughly in order to capture their voices, we are not likely to succeed in our contribution to the fight against impunity and to end a cycle of violence. What's equally important is to finding the right balance between the objective to maintain greater visibility and engagement of children and managing potential safety and protection risks. And this is also a very delicate and oftentimes challenging undertaking. Finally, in our recommendations, I would argue and suggest leveraging the commitments and support from UN member states and relevant intergovernmental agencies so that predictable and sustainable resources are mobilized to maintain greater engagement with children and their visibility in the human rights investigation process and outcomes. I thank you for your time.